Today, the Supreme Court ruled unanimously, and that's important in this, that the police need a warrant before searching a cell phone or personal electronic device belonging to somebody who's being arrested. Chief Justice John Roberts stated, quote, "We cannot deny that our decision today will have an impact on the ability of law enforcement to combat crime. Cell phones have become important tools among members of criminal enterprises and can provide valuable, incriminating information about dangerous criminals. Privacy does come at a cost." I want to bring in our panel on this. Mark Furnish, professor of Brooklyn Law and has argued before the U.S. Supreme Court. Doug Van Oyst, founding partner of Carson Van Oyst, focusing on corporate misconduct, and one of the Legal 500, is one of the top influential trial lawyers in the nation. And Jimmy Kasouras, criminal defense attorney at Manhattan, lecturing at New York Law School and a visiting professor at the University of Birmingham in England. Guys, thank you. Talk about the significance of the decision, Mark, and also the significance it was 9-0.
Well, symbolically, it is very significant that it was 9-0 because just a couple of years ago with the Jones case on the GPS devices, the court was fractured with regard to the rationale behind that decision. And here you see all 9 of them jumping into the digital age with, well, I guess 18 feet, right? And it's a very significant decision, one that finally lives up to the billing.
But and they said that this thing, Mark, and I'm holding a cell phone here, that it's no longer, calling it a cell phone, they said it's a misnomer.
It's more like a house.
It's so much more, right, and it's you. Did that play a role into why they ruled this way?
Yeah, I think absolutely. In all of the different kinds of digital issues that are percolating out there, GPS devices, phones, laptops, cell site data, cell tower dump data, all of these things, when you take all the information that's stored in these things, they paint a picture of somebody's life, virtually every facet of their life that any one physical object couldn't replicate in any way. And I think they're recognizing that, and our expectations of privacy in these devices are changing, and the Fourth Amendment has to be adjusted to keep up with those changes.
You guys are closer to me, Doug, but trying to figure out where the line on privacy starts and stops, where technology clearly is outpacing the law right now. And this decision helps to a degree, but they can search your wallet, they can't search your phone. Can you tell me why you can do one and not the other?
Well, I mean, I wouldn't begin to tell you why, but I can tell you that the Supreme Court has made a clear statement here that they believe, and they're all uniform on this, that there are boundaries, there are clear boundaries. And I think this is, when you look at this in light of what's going on with the NSA, Fourth Amendment, this is a clear statement from one of the branches of government that there are strict limitations.
And I got to imagine, Jim, there's going to be consequences to this. People have been, convicted on stuff that have been found on phones before. I got to imagine that some of these cases are going to be reopened.
Well, I would think so. I mean, I know here in the Southern District and the Eastern District, they don't search your cell phone unless they have consent or a warrant.
I've had them where they went incident to arrest without a warrant.
I mean, they usually call me and ask for consent. And some of them will be reopened, but you talk about drawing the line. The line to me was very bright here. I mean, you can search incident to arrest for destruction of evidence or to protect the safety of the officers. This just didn't implicate any of those concerns. And I think there's also a concern where if you were to allow this, then what are you going to do with a laptop? What are you going to do with a computer? What are you going to do with all of these other devices that have everything? Your iPad. If you open the door with this, they're going to come barreling through with everything else. And
Is there enough clarity, Mark, though, that we now know what they can search with or without warrants? He mentioned, for example, iPads, for example. Does that count, or?
Well, this is, on its facts, these are pretty narrow decisions. All it is a person who gets arrested. Can you take the device, be it the cell phone, be it the tablet, be it the laptop, if it's on their person or within the grab space, and search it without a warrant? That's all this means. Everyone agrees that they can seize the phone temporarily, call the judge and articulate probable cause. An electronic warrant will issue, and then they could search through it. So for what the decision means as the decision itself, it doesn't mean that much. To me, the interesting thing is the border searches of electronic devices, because every time we pass through a border at an airport now, they can search our computers, hold them and search them with no cause whatsoever. That's the next issue that's really going to get up to the court, and I look for that to come next term or the one after.
Well, there are some very interesting cases I want to get into, and part of them relate to the privacy debate, but also a debate over drones here and why a Seattle company apologizing to a local woman, trust me, nobody knows where this thing starts and stops where we look ahead, including in my world, in the world of journalism. We'll talk about that and some also other fascinating cases straight ahead.